Good morning to you all. I'll try to make this as brief as possible, but I don't want to start, of course, without my acknowledging my deepest gratitude to Bachelor in Maribor Faculty of Law and University of Maribor for inviting me to be here today and sharing with you some aspects of my experience. Now, within the framework of this project, I'm some sort of an alien because, unlike most of you, I'm not a procedural lawyer. I'm a European Union lawyer, and especially on the matter of competition law. So basically, I'm a little bit outside of my field of work. Anyway, for the past few years, I've been working a lot with comparative law, and that is what I am about to talk to you about. Now, right. Competition law nowadays is important in the EU. We've got some funding programs in several areas of law, of course, and some 542 million euros are going to be invested in research within the framework between 2007 and 2013. Among these programs, we've got something like 60 million plus for comparative law research. Now, comparative procedural law research, actually, it's accountable for this amount of money. Now, what is comparative law? Why is there comparative law in the European Union context, and how to do comparative law research? Now, the birth of comparative law, it was long ago with Plato and Aristotle. But modern comparative law started in the early 1900s with the Congress in Paris. Now, comparative law is basically what Zybert and Kurtz have been writing about. It has to do with, on one hand, market comparison. That's comparing the style and spirit of legal systems, methods, and procedures. Now, comparison of legal institutions on the other hand, has to do with micro comparison. So, how to solve actual problems or conflicts of interest. Now, one thing we have to keep in mind is that comparative law is not comparative legislation. Now, what does this mean? We have to look at the whole distinction between law in the books and law in action. Now, meaning that what we might look for, we should look for, is actually law in action and not the law in the books. Now, there are some dominant comparative law paradigms. We've got encyclopedic comparison, constructive, comparative historical, juxtaposition, and functionalism. Now, encyclopedic comparison tends to deal a lot more with comparative legislation rather than comparative law itself. It does bring a comparison, a portrayal comparison of laws, whereas constructive comparison it has a prescriptive approach. It tends to update, define, and improve some legal orders. Now, historical has been used in within the European research framework for some groups, and basically looks at the evolution of principles of law. Now, juxtaposition plus tends to compare, now looking at law in action, comparing cases, doctrine, jurisprudence, and statutes, having attention to interpretative, historic, and systemic additives. Now, functionalism is the system we are using nowadays. This sort of projects look much more into the function that rules that the law is fulfilling in a given system rather than the law itself. Now, all these methods do have some common methodological principles. The first of which, of course, is common sense. Research must be presided, governed by common sense. There is a tendency today so that this sort of research is conducted within a group of multinational components. Basically, we understand, we realize that it's not possible for one researcher to have a look into a given system that is not its own. And we use, most of the time, the questionnaire technique. Now, why should we study comparative law in the European Union context? Well, some years ago, almost 120 years ago, Lambert was aiming to create the common law of mankind, of humankind. And nowadays we are looking at the common law of the European Union. Now, specifics on European procedural law. We start to have now harmonized, unified law. So, law in the books is basic, can be actually either the same or can be harmonized. Now, the difference arises, because of this, in the local practice. And this means that we have to look at the function that the rules are trying to fulfill. Now, I'm going to give you, very briefly, a very short example, which I dare to make, to present to you for one simple reason. Although I'm Portuguese, I spent some time researching and studying in the UK, so I kind of feel able to do this. But it's a very small example. Now, how would we start a small claim procedure in England and Wales? And we have to keep in mind that Britain has got two different systems, one for England and Wales and one for Scotland. Now, in England and Wales, there is no specific order for payment procedure. Now, this means that we have to use a regular civil procedure to try and collect a small claim. Now, of course, there is one fast track, and that's the possibility to get a judgment by default, which is an uncontested claim. But that's the only thing that we have really in England and Wales. Now, the other thing that we might try is to have a look at the small claims track. But then we have a limit of £5,000. Although it is possible under certain circumstances to go above this limit. Now, where do we find the claim? Now, the English structure, of course, is quite confusing because we've got some we've got the high courts, we've got the country courts, we've got both of them knowing cases in the first instance. Some limit on the value of the claims can apply, but then there are so many exceptions to this that it's really hard time to try and understand where to lodge it. Now, the only way I could get to these answers, obviously, was using functional methodology. Could it be answered with some other technique or paradigm within comparative law? Yes, it could have, but just for you to think about the English system of courts in English judiciary, I've got this map here describing, and I'm not sure if you can have a look at the arrows, and it's a really complicated one to have a look at, and but we'll have this on paper, and you can spend maybe a couple of hours trying to decipher the puzzle that you will have before your eyes. Thank you very much, Jesus, for your time.